All right, today we're jumping into this amazing story where history, high drama, and the law all crash into each other. You've got William Shakespeare, you've got bulldozers, and you've got a landmarked court case that ended up changing the rules on who gets to speak for our shared past.
So let me ask you this. What happens when a priceless piece of history, something you thought was gone forever, is standing right in the way of a shiny new office building? The bulldozers are ready to roll. What do you do?
Well, believe it or not, that's exactly what happened. Our story kicks off back in 1989, right in the middle of London, with a discovery that sent absolute shockwaves through the worlds of theater and history.
Okay, so get this timeline. The Rose Theater was built way back in 1587. And this wasn't just some old building. We're talking about the place that staged early plays by Shakespeare and his big rival, Christopher Marlowe. But by around 1606, poof, it was gone. Just swallowed up by the city and completely forgotten for nearly 400 years. Until, boom, a construction crew hit something that is definitely not just dirt and rubble.
I mean, just let that sink in for a second. These weren't just old bricks. This was the literal ground, the actual stage, where some of the greatest plays ever written first came to life. For anyone who loves literature, this was like finding a lost pyramid. It was a direct physical connection to Shakespeare himself. But, of course, there's a catch, right? That site was all set to be paved over for a new office block. So the discovery sparked this immediate, passionate, massive public outcry. The battle for the Rose was officially on. And that became the rallying cry. Our heritage is not for sale. And listen, this wasn't just a handful of stuffy academics. We're talking famous actors, major politicians, and just regular people, all joining together, holding vigils and protests right there on the site. Their argument was simple. You can't just sacrifice a piece of world history for some more office space. So to get organized, they did something pretty smart. This group of passionate citizens formed an actual company, the Rose Theater Trust. Now, their first goal was straightforward. Just convince the government to make the site a protected national monument. But when that didn't work, they moved on to Plan B, take them to court. And just like that, the fight moved from the streets into the courtroom. Suddenly, it wasn't about passion and protests anymore. It was all about dry points of law. The trust filed a lawsuit against the government, specifically going after the Secretary of State for the Environment. So the conflict was crystal clear. On one side, you had the trust saying, look, this is Shakespeare's theater. It's so obviously important you have a duty to protect it. But the government side basically said, hey, deciding what is and isn't a monument is our call to make. It's a policy decision and the courts need to stay out of it. So the case goes to the High Court. The hopes of thousands of people are riding on this decision. And the central question isn't even about history anymore. It's about the law itself. So what would the court decide? They lost, just like that. And here's the absolute kicker. The court didn't even get around to debating whether the Rose Theater was important enough to save. The whole case was just thrown out before it could even really begin. Which brings us to the million-dollar question, right? How is that even possible? How can a group formed for the sole purpose of protecting this site be told they don't even have the right to argue their case in court? Well, the answer comes down to a really fundamental legal idea. It's a fancy Latin phrase, locus standi. In plain English, it just means legal standing. You see, you can't just sue the government because you disagree with something they did. The law says you have to prove you have a sufficient interest in the matter. And usually that means showing it affects you directly, like your property or your finances. Just being a very concerned member of the public, well, that's often not enough. So the judge looked at it like this. First, he said, okay, none of the individual members of the trust were personally harmed in a way the law recognizes. Their property wasn't at stake. Second, the trust itself was a brand new group, created specifically to campaign on this one issue. And third, and this is a classic legal argument, he worried about opening the floodgates. He feared that if he let this group sue, it would open the door for any group to challenge any government decision, and things could just grind to a halt. Now, the story of the actual theater site has a sort of happy-ish ending. A compromise was eventually reached, the bulldozers were held off, and the Rose is still there, partially preserved. But the legal legacy of this fight, that's what really changed the landscape for anyone fighting for the public interest in the UK. The Rose Theater case set a really powerful precedent. It created a much, much higher bar for groups to prove they had that sufficient interest. The message from the court was stark. Passion, moral outrage, and even massive public support don't automatically buy you a ticket into the courtroom.
For decades after, this ruling made it significantly harder for environmental groups and heritage campaigns to hold the government accountable. And this is the huge question we're left with, isn't it? If a dedicated group of citizens like the Rose Theatre Trust can't get legal standing to speak for history, then who can? Who gets to stand up in court for the environment, for heritage, for all the things that belong to all of us? This case blew that debate wide open, and honestly, it's a question we are still trying to answer today.